The views and opinions expressed on all radio shows broadcast on Tom's Radio Toronto are entirely those of the hosts, guests, and callers who are entirely responsible for all show content and do not in any way reflect the opinions of Tom's Radio Toronto or its staff. These broadcasts are presented and made public as entertainment and general information only, in the hope that they will be entertaining and informative to listeners. They are not intended to diagnose, treat, cure, or mitigate in any way any disease or condition or to promote any specific lifestyle, belief, religion, political affiliation, or other personal practice, nor is the information presented necessarily accurate or verifiable.
Good evening and welcome to Tom's Radio and the Hoffman Law Show. I'm Jennifer Hoffman. I am your host this evening, and I am also a principal lawyer at Hoffman Law. We are a personal injury and disability law firm. We are going to be together for the next hour or so talking about all things law related to personal injury and disability. For those of you that have been listening over the past few weeks, we've spent quite a bit of time talking about all the options that people have with respect to legal options that they have if they're injured, if they get hurt in an accident, a car accident, a slip and fall, dog bites, and also options for people who aren't able to work because of injury or are not able to work because of medical conditions. And we've received quite a bit of questions over the past few weeks about some of the information that we've discussed on the show. And so today I want to take the time to address some of the questions that have come up over the past couple of weeks. I want to thank all of our listeners for sending in your questions. Please continue to do so. I also want to remind listeners that if we talk about anything of interest on the show and you need further information, or if you've been injured and you require further information, don't hesitate to contact us. You don't only need to contact me during the show, you can reach me anytime. You can find us at www.hoffmanlaw.ca or call us at 416-631-0000. I'm at extension 1, and you can always also reach me at 647-330-5364. Anytime you have questions, consultations are free. We work entirely on a contingency fee basis, meaning you won't have to pay anything up front. And essentially, you would only ever have to pay legal fees if we are successful, if we take on your claim and we're successful at obtaining compensation for you for your injury. So let's jump right into it. I've got a list of questions that have come through, and I want to try and address each and every one of these questions. Hopefully we're going to have enough time to do that today. The first question comes from a gentleman who was involved in a boating accident, and it reads, I was involved in a boating accident. I was coming around a bend, and the other boat was coming from the opposite direction. Our boats collided. He's blaming me for the accident, and I believe it was the other boat's fault. There are no witnesses. What are my options at this point? So we have a situation where we have two boats out on the water. They're both traveling, and from the sounds of it, they collided either head on or they may have hit each other on the side as they were passing one another. Boating law is very different from other areas of law in terms of obligations, and it's regulated by what's called the Marine Liability Act, and
Me at
there are strict rules on how boats need to be operated out on the water. Again, every situation is very specific, and I would have to speak with you to obtain more information about where on the water you were, how far away from shore you were, how far away the other boat was from the shore, how big of a bend this was, how wide of a lake, I'm assuming this was a lake, how wide of a lake this happened on. And all that information is critical However, in general, the boat that is traveling to the right and close to shore has the right of way typically. There are buoys and indicators on the water of where boats are supposed to be traveling and operating. There are rules to how you operate the boat, and quite frankly, that's why it's critical that you obtain a proper boating license before operating a boat. Um, there oftentimes we see people who will go out to their cottage or rent a cottage and they want to rent a boat and they don't own a boat but they want to rent a boat and they get what's called temporary licenses to operate a boat. Those could be very problematic. If you have a temporary license and that is a legal thing, it is allowed by the province, you are allowed to get a temporary license kind of on the spot as you rent the boat. That's problematic because a lot of people who have these temporary licenses are not well versed in the rules of operating boats on the water. And so it becomes critical that before you go out on the water, familiarize yourself with the rules, familiarize yourself with who has the right of way, and make sure that you properly understand how to operate a boat so that you don't cause injury either to yourself or to another person. Um, I've done quite a bit of boating accident work, and I can tell you from from my experience that the injuries that people suffer as a result of boating accidents are often extremely serious. We're talking about major injuries, injuries that are debilitating, that can lead to further disability, and unfortunately, sometimes death. So take it seriously. If you have a question, this gentleman that wrote in to me, if you need to speak further about it, I'm happy to do so. Again, you can find us at www.hoffmanlaw.ca, and consultation is free. Let's go on to the next question. One of our listeners wrote in saying, I slipped on a slippery floor in my apartment building. The landlord is being very aggressive when I told him that I want to speak to a lawyer. He said it'll cost me a lot of money to hire a lawyer and I'm not entitled to anything. Is that true? Well, first of all, it will not cost you a lot of money to hire a lawyer. This landlord sounds pretty unreasonable to me, and it sounds to me like this landlord is trying to intimidate you and prevent you from seeking legal counsel or legal advice. The way it works with most personal injury lawyers, including myself, is that consultation is free. And like I said earlier, we take these types of cases on typically on a contingency fee basis, meaning you don't pay anything up front, you don't pay out of your pocket to build a case. We do that on your behalf. And if we think that there's a good case and a worthwhile case for us to proceed, that's the kind of risk that we take. And we wouldn't take your case on unless we thought that there was a reasonable chance of success. So no, you will not have to put any money out by seeking a personal injury lawyer. I highly encourage you to speak to the lawyer about your injuries, whether you have a case or not. And I know your landlord told you that you're not entitled to anything, but with respect, I'm not sure that the landlord is also a lawyer. You absolutely might be entitled to something. You might have a viable claim. So I very strongly encourage you to reach out, speak to a lawyer. If you've sustained injuries as a result of this fall and these injuries continue to impact your life, absolutely. Let's have a call. Let's discuss it further. I would need more information on what type of injuries you've suffered. I would also need more information on how the fall occurred. In one of the previous shows, we talked about liability, and specifically liability in slip and fall cases. And typically when people get hurt due to a fall, the injuries are pretty significant, but the legal issue that we often have to battle relates more to how the fall occurred as opposed to the injuries that you've suffered. So oftentimes the challenge, and this is where you want a lawyer to be involved, is proving that whoever owns the property, be it a private property owner, like this building, I would imagine it's privately owned, or a government or municipality sidewalk, for example, you have to prove that the owners were negligent in how they kept the property, and that the onus or the test differs depending on the different circumstances, whether it's private versus public property. So, I based on your question, on the information that I have, it's impossible to tell if you actually have a claim or not. But I very strongly encourage you to speak to a lawyer. Contact us if you need 416-631-0000 or 647-330-5364. Anytime, I'm happy to walk through the case with you and talk to you and let you know what your options are. Let's do one more question before we go to a commercial break. I was in an accident last fall. I didn't think I was injured or hurt, but I have a lot of pain now in my hip. Is it possible that it's caused by that accident? I fell in the exact area of the pain. Okay, so this person doesn't specify what type of accident they were in, but just based on the question, I'm going to assume that again it's a slip and fall, so it ties in nicely with the previous question. Again, oftentimes when we're injured, unless we're talking about massive injuries, unless we're talking about obvious injuries like, you break your leg, you break your arm, you hit your head and you lose consciousness. Sometimes we get hurt in accidents and we don't realize the extent of those injuries or how serious those injuries are until later on. Especially if we're in a state of shock or our adrenaline is running, we don't always have an appreciation for the extent of the injury until later on. So sometimes I have clients come to me and they've been involved in an accident and they didn't immediately have an onset of pain, or they had pain and they thought that it wasn't serious, so they didn't go to the hospital right away, or they didn't go seek medical attention right away. And then, unfortunately, over time, what happens is a lot of these injuries worsen and the pain gets worse. And that's the point that some clients seek medical attention for the first time, and they're concerned that because they didn't go right away, they may not have a case. In one of the previous shows, we talked about the importance of seeking medical attention right away, and that still stands. I really encourage all of our listeners, if you've been injured, be it in a car accident, a slip and fall, a boating accident, any type of accident, a work-related injury, seek medical attention immediately for two reasons. Yes, of course, if later on you want to pursue a claim, it helps in the litigation and in the lawsuit. But more importantly, it's critical that a medical professional sees you, assesses you, and is able to run whatever tests they need to make sure that you're okay. Particularly when it comes to, let's say, hitting your head or brain injury or concussion and any of those types of injuries. But specifically, back to this listener's question, just because you didn't seek medical attention right away, it doesn't prevent you from having a lawsuit if you decide to pursue one later on. We have a limitation period in Ontario. Most cases have 2 years to start a lawsuit. So keep that in mind when you're considering whether you have a right to sue or not. But certainly, when you hire a lawyer like myself or my law firm, we have the resources to investigate the medical condition. We have the resources to send you to the proper medical experts to provide us opinions on things such as causation and whether your conditions are related to an accident or not. So absolutely speak to a lawyer. Don't discount or walk away from a potential lawsuit just because you didn't go to a doctor right away. Give us a call. We'll walk you through it. And if we think that there's a viable claim there, we will certainly let you know and we will pursue it aggressively on your behalf. So that's essentially what I'd recommend in circumstances where someone didn't seek medical attention right away. And again, I want to encourage all of our listeners to always consult a lawyer before making any decisions. You can call my firm anytime, 416-631-0000, extension 1, or 647-330-5364. If you want any more information about any of these types of injuries or what we do, feel free to go to my website, www.hoffmanlaw.ca. And let's go on to a quick commercial break.
Our company is committed to providing truthful, honest, competent, and result-oriented service through advising and representing our clients in Canada and overseas in a wide range of immigration matters. We focus on providing support, building dependable relationships, and promoting success. We are dedicated to understanding what results you want and to helping you understand what actions we can take on your behalf.
Good evening and welcome back to the Hoffman Law Show, where we talk all things law. Today we are taking the numerous questions that we've had over the past couple of weeks from our various callers, and we're going to be answering a lot of your questions. Feel free to call in during the show or to Skype in. Information is on the screen. You can call in at 416-900-5864 or at Skype Tom's Radio. If you have any questions, please feel free to contact us. You can also reach us at hoffmanlaw.ca or call us at 416-631-0000, extension 1, or 647-330-5364. If you do have any additional questions after the show, feel free to reach out. I'm always happy to take your questions. So we have another question that came in by a gentleman who was struck by a vehicle while riding his bike. Apparently he was knocked off of his bike and the car that hit him took off, which is just outrageous, but it is what it is. It appears that this gentleman doesn't know who which car hit him or who the driver is of the vehicle that hit him. He has no identifying information about the vehicle that hit him, and it seems that he suffered quite a few injuries, including a fractured leg. He had to have his leg casted, and now the doctors are saying that he requires more physiotherapy and other treatment. And he wants to know what his options are because he has no information on the vehicle that hit him. So, first of all, we've previously discussed about how every Ontarian is entitled to what's called accident benefits. At the very, very least, you will be entitled to accident benefits, or ABs, which are essentially benefits that people need shortly or immediately after being injured. So, for example, payment of physiotherapy, chiropractic treatment, massage therapy, any sort of treatment that isn't covered by OHIP would be likely covered under the accident benefits and paid for by accident benefits. Whether you have insurance or you do not have insurance, there are ways to access this. In this types of circumstance, if you don't have your own insurance and this vehicle took off and you can identify him, there is a way to access accident benefits through MVAC. It's a fund that is set up by the government that provides accident benefits for people who are injured in these types of scenarios who don't have their own insurance um, policies or have no access to their own any type of insurance. Um, Benefits can also include things such as income replacement benefits for people that aren't able to work, so on and so forth. So that's kind of the immediate need that you may have soon after an accident. Obviously, when the cast comes off, you will require physiotherapy, and I encourage you. The fund can be complicated to deal with, and I would encourage you to reach out to a lawyer and have a conversation about what might be your options in terms of accident benefits. What most people don't realize is that even if the vehicle that caused the accident takes off, be it two cars colliding or a car that strikes someone as a pedestrian, or a car that in this case struck a bicyclist and leaves the scene of the accident, even in those circumstances, you may still be entitled, entitled isn't the right word, I would say you may still be able to pursue a lawsuit. And, when I tell this to clients, they often say to me, well, who am I going to sue? I don't know who hit me. I don't know who this other car is. It went off. It left the scene of the accident. Who am I going to sue? And the answer to that is that in Ontario, we have legislation or law that says that if you're struck by an unidentified vehicle, you can still pursue a lawsuit as against your own insurer, and your own insurance company will step in as though they are in the shoes of the other vehicle that struck you. Now, obviously, this only applies to people who do have access to insurance. So let's say you're driving a vehicle and you're struck by an unidentified driver. You're obviously insured under your own vehicle and you can pursue this. If you're a bicyclist or you're a pedestrian and you also have a driver's license and you have insurance, you'll be able to access this. If you are a pedestrian or a cyclist and you don't drive or you don't have your own insurance, you may still have access to an insurance, an MDA insurance policy, through someone else in your household. You might, if you are a minor or a dependent of someone who has insurance in your household, you may have access to this. If you don't meet any of the above criteria, unfortunately, there aren't that many options left. But again, it's very, very case specific. Trust me when I tell you, when you contact us and you've suffered these types of injuries and with an unidentified driver, we will turn over every single rock and look at every single potential opportunity to access insurance for you and to be able to sue on your behalf. So definitely, if you're in these types of circumstances, I know most people think that if they don't have insurance or if they don't have information about the other car that hit them, that they can't pursue a lawsuit. That is not correct. You can still absolutely pursue a lawsuit if you are involved in that sort of situation. And I strongly encourage you, speak to a personal injury lawyer, give them the information, and find out what your options are. In terms of physiotherapy and other treatment, again, you do have access to accident benefits, but oftentimes when you've been in a hospital and you've undergone surgery or fracture, major injury, there are ways for OHIP to cover physiotherapy. It could be a little bit complicated, but it's not impossible. So again, speak with a lawyer, find out what your options are. We'll do everything to ensure that you get timely access to rehabilitation therapy. Okay. This is a very interesting one. I was T-boned in an accident while I was making a left turn. I was on a yellow and the other car ran the light to get through the intersection. The police charged me. Me and my passenger are very badly injured. What are my options now? I saw in your last show that I might be entitled to ABs even if I'm responsible for the accident. Can you please clarify? So this is interesting because um, fortunately or unfortunately, the way our law is set up in Ontario is that typically the vehicle that is making a left turn is charged if there's an accident. Even if they're not at fault, even if they were prudent and reasonable, they're likely the party that is going to be charged because there is there is the notion that when you're making a left turn, there is an added onus on you to be careful and to execute that turn carefully. What happens sometimes, and I've had this happen in my practice, and I've had clients with these situations, is that a driver will come up to a green light and wait to make a left turn until it is safe to do so. And they're waiting and waiting, and the traffic is going through on the other side. And then finally, the light turns yellow, and all of the cars start to slow down, and it's safe to turn left, and they commence their left turn, and then some aggressive vehicle coming from the other direction decides that they need to beat that red or they need to beat that traffic light, and they drive right through. They press on their brakes, they accelerate and speed right through the intersection, and bam, that's when you're left with really, really serious accidents and really serious injuries in these types of circumstances because the impact is typically quite high because the other vehicle is accelerating to get through the intersection. In those cases, even though the other vehicle accelerated, in the majority of those cases, the police will still charge the person who's making a left turn. I think in my entire career, I've only ever seen 2 or 3 incidents when the other vehicle was charged. It is extremely rare. But just because you got charged in those circumstances does not mean you are responsible for this accident. First of all, getting charged is very different from being convicted. Just because you're charged or accused of doing something does not make you guilty of it. It does not make you guilty of being reckless. It does not mean that you are responsible for this accident. They have to prove their case and convict you in court. Okay? And even if you go to court and you pay a fee and you get convicted, that's still civilly, in terms of a lawsuit against the driver that sped through the intersection, you may still be entitled to a lawsuit against that driver. As always, it's very fact specific in these types of circumstances. I know there's a lot of chaos at the scene of an accident, but try to make note if you're ever, God forbid, involved in something like this. Make note of who the witnesses are, what some of the surrounding vehicles are, even if you just get license plates, so that you can later bring witnesses to testify about who caused the accident. Oftentimes we get evidence from both drivers, and one person's story makes more sense than the other person's story, and so just because the left turning vehicle was charged doesn't mean that if you were injured that you can't pursue a lawsuit. And I've had quite a few cases like that. In fact, I had one case a few years ago. It was a really, really big, very serious accident. Unfortunately, my client suffered very serious injuries. She was turning left and another car sped up to try and beat the intersection, beat the light. There was a huge crash. Airbags exploded. Cars were written off. It was terrible. My client never worked again since this accident. And the lawyers for the insurance company kept saying, your client was making the left turn. They're responsible for the accident. And we had enough information and enough evidence to suggest otherwise. We fought it. We were successful. And my client obtained a very, very large sum of money in their settlement. I can say near the $1 million range. So, you know, eh, just because you made that left turn, don't think that you're necessarily going to be held responsible for the accident. Give me a call. We can talk about it. We're going to look at the specific facts of your situation and discuss what options you have in the circumstances. Okay, so just a reminder, you can always reach us at www.hoffmanlaw.ca. I'm Jennifer Hoffman, your host, principal lawyer of Hoffman Law, and we're going to go to a short commercial break. Thank you.
Our company is committed to providing truthful, honest, competent, and result-oriented service through advising and representing our clients in Canada and overseas in a wide range of immigration matters. We focus on providing support, building dependable relationships, and promoting success. We are dedicated to understanding what results you want, to helping you understand what actions we can take on your behalf.
Good evening and welcome back to the Hoffman Law Show. I'm your host, Jennifer Hoffman. I'm also the managing partner of Hoffman Law. We are a personal injury and disability law firm, and we are here today answering all of the questions that have come in over the past couple of weeks while listeners were listening to our show. And I want to remind our viewers that if you have any questions, I'm happy to take them. I'm happy to speak to you. You can reach us anytime. Free consultation. You can find us at hoffmanlaw.ca or call us at 416-631-0000, extension 1. If you have any questions during this show, feel free to call in 416-900-5864 or to Skype at Tom's Radio. I'm happy to take your calls. I'm happy to take your questions. So we don't have much time left tonight. Wow, time flies when you're having fun. So I want to try and get to the rest of the questions that we have here. We have another question about a gentleman that was injured at work. This person was approved for long-term disability. They got injured in a car accident and can't work. I apologize. I misread that. This person was injured in a vehicle in a car accident. They're no longer able to work. Their long-term disability approved benefits, and this is through work, but the car insurance is saying that because this person is receiving long-term benefits through their work policy, that they're not entitled to income replacement benefits through accident benefits. Is that true? No, that is not true. A lot of insurance companies, motor vehicle insurance companies, are going to say to you, you're receiving LTD, you're not entitled to IRBs. That is bull caca. You are entitled to both, depending on your circumstances. Like everything else in law, depends on the facts. Under accident benefits, and those are the benefits that you get through your insurance for the vehicle, you are entitled to up to 70% of your gross income, up to $400 a week, unless you have additional benefits, and that's a different story. Again, that's very case specific, but the majority of Ontarians have basic accident benefits that entitle them to up to $400 a week. up to 70% of their gross pre-accident income. Now, just because you're receiving long-term disability does not mean that you may not also be entitled to IRBs. If your long-term disability payments don't cover the full 400 or 70% of gross. Okay? So what does this mean? If, let's say, you are actually entitled to, and there's a mathematical formula for this, and the insurers have their accountants and we have our accountants and we figure out the numbers, but let's, for example, for today's purposes, let's say you're entitled to $400 per week of income replacement benefits, and let's say that your long-term disability carrier is paying you $300 a week in benefits. That's a shortfall of $100. Your auto insurance is responsible to pay that difference. They are responsible to pay the $100 per week. A lot of people don't know this. A lot of lawyers don't know this. And quite frankly, some adjusters in insurance companies don't even know this. But that is in fact the case. If there's a shortfall between the benefits, the vehicle insurer is still on the hook to pay that difference. The reason oftentimes they think that they're not is because if you have a source of income and LTD benefits is considered a source of income, then they think they're no longer on the hook. Not the case. They have to pay you the difference. That's kind of a simplified explanation. It is a bit more complicated than that. So again, call a lawyer. If you're having these types of issues, it's really important that you seek legal advice. You can contact us at Hoffman Law anytime. We will speak with you for free. We'll not charge for an initial consultation. We don't charge anything up front. Everything is done on contingency. So don't hesitate to contact a lawyer. Don't worry about the finances of dealing with lawyers. Contact us. We'll walk you through it, and we'll make sure that you get everything that you're entitled to. The next caller got injured in a car accident. I went back to work after the accident, but then my pain got worse and now I can't work at all. My insurance says that I'm not entitled to income replacement benefits because I returned to work. Is that true? No, that is not true. Again, these insurance companies, yes, okay, the person went back to work, they attempted a return to work, and now they're off work because of an accident, because of an injury. They are entitled to income replacement benefits. Sometimes, depending on how long after the accident you're applying for IRBs, that's income replacement benefits, I'm going to refer to them as IRBs, there may be additional complications, but if you're not able to work because of an injury you sustained in a car accident, do not let the insurance companies tell you that you're not entitled to IRBs. You're absolutely entitled to IRBs. You may have a delayed application for them. There may be assessments involved. There may be additional disability certificates that need to be submitted. There may be additional medical documentation that needs to be submitted. But you are still entitled to income replacement benefits. This is a very complicated area. I strongly encourage you, speak to a lawyer. Everybody's situation differs, everybody's circumstances differs, and a lot of your entitlements will be very fact specific based on your personal situation. But in general, even if you've gone back to work after an accident and some time goes by, and oftentimes injuries get worse over time and people are not able to work, you are still entitled to income replacement benefits. It just might be a more complicated application process and a more complicated process to prove that you're entitled to those benefits. Also, I just want to remind all our callers and listeners that if you get denied benefits by your insurer, you have 2 years to dispute those denials. If you're past the 2 years, it might be SOL. You lose your right to dispute them. You lose your right to commence an application to the LAT to dispute them. So that's why as soon as you have a denial of either income replacement benefits or treatment, anything like that, speak with a lawyer immediately because there are timelines that you need to be cognizant of and that we need to work with. Next question. I heard on one of your shows that you have to let the city know within 10 days after you've had a fall. I fell a couple of months ago and I have been in the hospital since with a broken leg. I had a couple of surgeries and complications. I'm sorry to hear that. I had no idea that I had to let the city know within 10 days. I didn't notify anyone yet. Can I still sue the city if I didn't properly notify them? The short answer is yes, and we'll get into the details after the next commercial break.
Our company is committed to providing truthful, honest, competent, and result-oriented service through advising and representing our clients in Canada and overseas in a wide range of immigration matters. We focus on providing support, building dependable relationships, and promoting success. We are dedicated to understanding what results you want and to helping you understand what actions we can take on your behalf.
Back to the Hoffman Law Show. Just before our break, we took a question with respect to a slip and fall that occurred on city property. This listener had fallen on city property and sustained some pretty serious injuries. He's been in the accident since. This was a couple of months ago. This person has been in the accident and has had several surgeries. They weren't aware that they needed to notify anyone until they heard on our show, I guess last week, that the city needs to be notified within 10 days, but unfortunately this person has been hospital bound and dealing with surgeries and unfortunately complications. So they didn't notify the city within the 10-day requirement, and they want to know if they can still sue and what options they have. So yes, you can still sue. It's in these types of circumstances, there are ways of getting around the legislations or the law that require the 10-day notice period. So just to remind our listeners, whenever you are injured on city property and you want to commence a lawsuit, you do need to notify the city, and there are requirements for the type of notice that you provide the city. Within 10 days of the injury, you have to notify them of your slip and fall or your injury. And if you don't, you might not be allowed to sue them later on. Now, the exceptions to that is if you have a reasonable explanation for why you didn't notify the city. Lawmakers recognize that sometimes people that are severely injured are laying in a hospital bed. You're dealing with a fractured arm, a fractured leg, a concussion, a head injury, and you're not particularly concerned about speaking with a lawyer at that time or commencing lawsuits. You you're focused on getting better and getting the recovery that you need. So as long as there's a reasonable excuse for the delay in the notice period, then there could be a viable argument against it, and we can pass it. However, it does complicate things a little bit, and it is really, really critical that you speak to a lawyer. The lawyer will know the case law, the applicable case law. The lawyer will know the appropriate arguments to be made, and the lawyer will know how to fight the city when they try to say that your action is barred, meaning that you have no right to sue if you didn't give a proper notice. So very important, speak with a lawyer, get a free initial consultation, find out what your rights are. I'm more than happy to speak with you. Feel free to contact me at 416-631-0000. You can also contact us through our website at hoffmanlaw.ca. Even if you're at the hospital, we will attend the hospital if depending where you are, if we're permitted by because of COVID restrictions. But certainly, even if we're not able to physically meet with you, we do have the technology to have an initial consultation at least, and ensure that you're all set up and ready to go home before you're released from the hospital. So there's a lot of stuff you're going to need when you get to your home, and unlike motor vehicle accidents where there is an insurance company to pay for these things ahead, there's no insurance company typically in slip and fall accidents, and so you're going to need a lawyer to access their resources to ensure that you have everything you need once you get home. You're going to need assistive devices, you may need help around the house, you may need help with personal activities such as showering, toiletry. So make sure you speak with a lawyer. We can have you set up and ready to go as soon as you leave the hospital, so that you're not left at home on your own trying to figure out how to get around with such serious injuries. Okay, last but not least, I'm actually quite glad we managed to get through all of the questions today. I received an LTD benefits for a few months, then they cut me off. I had no choice but to return to work. I tried to work for several weeks, but I just wasn't able to. I went off work again, and now they're denying my LTD benefits. Because there was a period of return to work, can they do that? Okay, so from the sounds of it, this person suffered some sort of injury or had a medical condition that caused them to have to stop working. And they were receiving LTD benefits for a period of time, and then at some point the LTD carrier said, we're going to cut you off, you can go back to work. And then this person went back to work, tried it out, wasn't able to sustain themselves at work and had to get off work again. And now the insurance company is saying, well, since you returned to work, you're no longer able to receive these benefits. So we sometimes do see this when there is a return to work between what we call the date of disability and the date that the client claims for additional benefits. We do see that. The insured does not have a right to that. It's a lot more complicated than that. First of all, we would have to look at why this individual was cut off initially, and I can almost guarantee you that the cutoff was not legitimate, that even the initial cutoff of benefits was done inappropriately, that the proper medical assessments were not conducted to justify that cutoff, and that the insurer just, whoever was adjusting the file, looked at the file, made a decision that this person was medically able to get back to work, and decided that they will cut off the benefits and the person will go back to work. That is not a legitimate ground for cutting off benefits. The insurers are not entitled to do this. They are hoping that you just go back to work and forget about it and let it go. Do not let this go. If you have been denied benefits through your LTD, or if you've been cut off from benefits through your LTD, I can almost guarantee you that it was not done properly on the part of the insurance company, and that you will have a lawsuit against them. Speak to a lawyer. Find out what your rights are. it's really important, especially in these types of circumstances where there's been a break in benefits and a person has returned to work. It could get complicated. That doesn't mean that you're not entitled to benefits. If you have a continued disability as a result of the initial date of disability, whatever caused it, whether it's through an accident or through a medical condition, psychiatric condition, whatever the situation is, you are still entitled to benefits. Don't let your insurance company tell you otherwise. Oftentimes they are hopeful that people will just go back to work and not bother pursuing anything against them. They often do things in an improper way, and very, very, very often, in fact, I think about 99% of the time that people call me about LTD issues, there is a viable claim. There is a successful lawsuit against the insurance company for the unauthorized or non-legitimate denial of benefits. So call a lawyer, call my firm, Hoffman Law, www.hoffmanlaw.ca. You can contact us through our website. You can also call us anytime, 416-631-0000, extension 1, 647-330-5364. Again, my name is Jennifer Hoffman. Give us a call. We'll talk you through your particular issue. We'll give your advice based on your specific set of circumstances. We're happy to do that. Consultation is free. So don't ever hesitate to contact us. That's all the time we have today, folks. Thank you and have a great evening.